folks about 3 minutes to log in and then get started.
Hello, everyone. Thank you for joining our webinar entitled I-730 Requests for Additional Evidence and Affidavits. Today we're joined by Heather Scavone from the Elon University School of Law and Tara Pinkham from Church World Service. Just some technical administrative matters. If you have a question, please type it into the chat box or you can raise your hand. If the question is pertinent, we will discuss it during the webinar if it's based on the topic that we're talking about. We're also going to have a question and answer session. Heather will be presenting first on I-730 RFEs. After her session, we'll open it up to Q&A. And then I will be presenting on affidavits, and after my session, we'll open it up to Q&A again. So type your questions into the chat box, and you can also raise your hand. If you raise your hand, we will unmute you so you can ask your question, but we'll do that during the question and answer session. So thank you for joining us. Now I'm going to be turning this over to Heather Scavone.
Thank you, Tara. So in keeping with the festive season today, we're doing a presentation on a festive subject, which is dealing with I-730 requests for evidence and affidavits, because these things promote family reunification, which must be the warmest and fuzziest topic that you could come up with. So thanks for joining us, and we'll go ahead and proceed. The topic of the first half of our presentation is effective rebuttal strategies for I-730 requests for evidence. I-730s, and particularly those that are filed on behalf of beneficiaries from certain different countries of origin, carry a pretty substantial risk of provoking a request for evidence from CIS. And participants on the webinar have probably received RFEs from both Texas and Nebraska service centers, since we have different jurisdictions. Our office only deals with Texas, but many of you probably also have Nebraska. And both of those service centers have slightly different styles of generating their RFEs. I know since Nebraska was the original processing center for all I-730s, I feel like they're a little bit more finessed in the way that they generate them. In Texas, RFEs a lot of times look much like I-130 RFEs because I think historically that's what they have dealt with over the years. So the purpose of this webinar is to help you craft just a watertight rebuttal to any RFE that comes your way. And if you have been practicing and doing I-730s for very long, you've probably noticed that requests for evidence generated from I-730s are really among the most complicated evidentiary requests that you can receive. So you should pat yourself on the back if you have been dealing with them. In fact, I know for practitioners who only do in-court representation, they can tend to think of as administrative benefits as being, not that tough. I've heard them called vanilla, these vanilla administrative benefits and applications. But if you've done I-730s and you've received a request for evidence for one, you'll note that they're incredibly complicated, and often you'll end up writing, an 8 to 10 page, very complex rebuttal. And so as a result, I think it's a topic that's definitely worthy of our consideration today. Also, a quick little disclaimer. We organizer people who are doing the webinar can actually see if you are surfing the World Wide Web during the presentation. This is a fascinating feature of the webinar that I recently learned about. So just a disclaimer to you all as we get started that we will be spying on you through the presentation. So this seems elementary, but we need to start at the beginning with understanding the request for evidence before you craft your rebuttal strategy. So you need to approach each request for evidence for what it is, and it's really an exercise in statutory interpretation. Each RFE that you get with an I-730 requires that you do a thorough analysis of the legal issues before you begin contemplating your remedy. And the way to begin outlining your rebuttal is really by identifying the alleged legal deficiencies in the I-730, then identifying what documents USCIS is requesting in order to remedy that deficiency. And so by going through these steps, you'll be able to create an outline for your rebuttal. So the first thing is to read the entire RFE. This can be depressing if you get that white envelope in the mail, not the wavy line paper, which makes you happy because it's a receipt or an approval, but when you get the white envelope with the request for evidence in it, and as you're reading through it, you start to feel like the USCIS argument is really persuasive and your client is totally sunk. But you can't despair because it only sounds persuasive for a minute, and then when you start to think about it, you have lots of good tools to overcome the RFE. So the first thing is to read the whole RFE, and then next, identify and enumerate the legal deficiencies that are cited in the RFE. So identify each deficiency that CIS cites as being problematic for proving the petitionable relationship. And then finally, and those things may be explicit or they may be implicit. So they might state, you failed to meet the definition of a child because of X, or they might just give a description of what the deficiency is, and it's left up to you to identify the statute and figure out what the problem is. Then the third step is to identify what documents USCIS is requesting in the RFE in order to satisfy their request or in order to remedy the legal deficiency with the petition. So here is an example of sample language from an RFE that probably looks typical of what you've seen in the past, and we're going to read through it and then follow the two previously discussed steps so that it'll put us in a good place to outline our rebuttal. And this one says, you must comply with the following in order to establish that a bona fide parent-child relationship exists or existed between Mr. Smith and Child Smith prior to the beneficiary's 21st birthday. An illegitimate child may meet the definition of child for immigration purposes if it can be established that a bona fide parent-child relationship does exist or has existed between the child and the natural father prior to the child's 21st birthday. Furnish all documentation you have to demonstrate that such a relationship exists or existed. So before we start outlining our rebuttal, if we look at the steps again, we want to first identify and enumerate the legal deficiencies that are cited in this RFE. And we don't want to just take USCIS's word for it that the petition is actually deficient. That's a good reason for first focusing in on what the alleged deficiency even is. And what I mean by identifying the deficiency is that you must find the statutory requirement for the cited deficiency. So in this case, what are they lamenting, and what regulatory or statutory authority goes towards that deficiency. So in this case, they're stating that you must establish the existence of a parent-child relationship in order to meet the definition of child under the INA. So conceptually, I'm sure you're all familiar with this parent-child relationship concept, but we need to identify what is the statute that that's referring to. So the statutory requirement is in the definitions section of the INA. In section 101B is where the definition of child is listed. And among the definition, the various definitions for what counts as a child is listed 101B1D, a child born out of wedlock by whom or on whose behalf a status, privilege, or benefit is sought by virtue of relationship of the child to its mother or to its natural father if the father has or had a bona fide parent-child relationship with the person. So in this case, we find our statutory source at 101B1D, which says that you can only meet the definition of a child under the INA in the case of a petitioning father where it's an out-of-wedlock child if you also have a parent-child relationship with that child. And so if we fail to meet that definition for a wedlock child by a petitioning father, then the petition is in fact deficient. So that's step one, identifying the legal deficiency. So then step two is identifying documentation requested by USCIS in order to remedy the deficiency. And here you can see the last sentence in the slide. It says, furnish all documentation you have to demonstrate that such a relationship exists or existed. And so they're essentially asking you to furnish all documentation of the parent-child relationship. And we're not going to go into what all that might be at this point, because this was an exercise just in breaking down the RFE to begin to craft the rebuttal, and we will go over the different types of deficiencies that you're likely to encounter in a request for evidence a little bit later in the presentation. So finally, if we look at in the past example how we have both identified the legal deficiency, which is failure to meet the definition of a child at 101B, and then identified what document CIS is requesting in order to remedy this deficiency, in this case, proof of the parent-child relationship. Then finally, we need to respond to the allegations of the deficiency and provide requested documents if we determine that the requested documents are in fact necessary. So since we have the basic elements for the outline for the rebuttal at this point, we can look at this example, which gives us a sample outline. Our thesis of the rebuttal is essentially that the beneficiary meets the definition of an out-of-wedlock child under INA 101B1D, and as such, there's an approvable, petitionable relationship, and the I-730 should be approved. So again, looking at those steps, we've identified the deficiency, identified what documents USCIS is requesting in order to remedy the deficiency, and then we're responding to the allegations of deficiency and providing requested documents. You may not always need to provide the requested documents. It depends on if the alleged deficiency is in fact a deficiency in the petition. So in this case, pursuant to INA 101B1D, the beneficiary meets the definition of a child because a bona fide parent-child relationship existed between him and his petitioning father prior to the beneficiary's 21st birthday. Upon your review of the enclosed documentation submitted in evidence of the parent-child relationship between Mr. Smith and Child Smith, please approve the pending I-730 petition. So having gone through that example, next we're actually going to address what I'm sure is more interesting to you all, and that is how to specifically deal with the more common evidence requests that you might see in an I-730 request for evidence. This is not an exclusive list, and on this list we're going to go over in as much detail as possible each of them that we can. We may not have time for all of them. So at the top of the list is an issue that I'm sure many of you are familiar with, and that's that you get a request for evidence that takes issue with secondary documentation. So in other words, it requests primary documentation, civil issued documentation. It maybe states that secondary documentation is not sufficient, or the fact that you have no civil issued documentation and lists that as a deficiency. The next bullet is so-called late issued civil documentation. So this would be where CIS indicates that the documentation you've submitted was not issued contemporaneously with the event in question that it's trying to prove, and therefore they complain that it's not good enough to support the petitionable relationship. Under that we have illegitimate children or children born out of wedlock and issues arising from that situation, similar to what we were just looking at in the example. And then one of my favorites, non-disclosure of a relative on a prior benefits application. So in this case you have your petitioner doing an I-730 on behalf of a relative who he failed to list in a previous benefits application, most likely the overseas refugee interview, the I-590 application. And this one comes up a lot, particularly in certain populations. Under that we have adoption and issues related to cultural adoption, parent-child relationship, which is really collateral to the out-of-wedlock children issue, and then humanitarian extension of the 2-year filing deadline, as well as voluntary DNA, or they say they're voluntary. That kind of looks like you're required to submit DNA, but they state that it's a voluntary submission. We'll talk about that a bit too. And then if you're really, really lucky, maybe you'll get to deal with a proxy marriage and a consummation of that proxy marriage issue. Rare that that comes up, but lucky you if you get to talk about it. It's a fun thing to get to prove that somebody consummated their marriage. So what we're going to address first is the first issue on the list, which is secondary documentation, or so-called late issued documentation. Many refugee asylee petitioners are not able to obtain primary documentation in evidence of their relationship to the beneficiary. This is something I don't have to tell you. I know you guys probably have dozens and dozens of clients with this problem all the time. So for example, birth certificates, marriage certificate, etc., they may not have access to that type of primary documentation that's civil issued. And if USCIS requests primary documentation and your client is not able to obtain it, you can argue that secondary documentation is sufficient. In arguing the sufficiency of that secondary documentation, such as affidavits, you'll also want to document any attempts that your client has made to obtain primary documentation. Foreign Affairs Manual Appendix C of Section 9 indicates what types of documentation is required for U.S. visa reciprocity. So for every single country that a petitioner might come from or that a beneficiary might be associated with, there's this reciprocity table that will tell you if in that country certain documentation is available or unavailable. And if Appendix C states that primary documentation is unavailable, then there's a clear mandate for USCIS to accept secondary documentation such as affidavits. And so in your tools that I have listed here on the slide, the first bullet has 8 CFR 204.1 F1, and this states that when it's established that primary evidence is not available, secondary evidence can be accepted in favor of approving a petition. So to determine the availability of primary documents, the service will refer to the Foreign Affairs Manual, and they're specifically talking about Appendix C. So again, if Appendix C states that a document is not available, then you automatically can invoke 204.1 F1 and say that you are going to submit secondary documentation. Another provision here, and I should say the second provision, 204.1 G2, it's only collaterally relevant to this situation because it's actually talking about secondary evidence of the petitioner's status, such as being an LPR, refugee, or a U.S. citizen. And it says in the case of trying to come up with proof of that status, if primary evidence is unavailable, the petitioner must present secondary evidence, and any evidence submitted as secondary evidence will be evaluated for authenticity and credibility. It may include, but is not limited to, baptismal certificates, affidavits, early school records, and census records. So it's just kind of giving us an idea of what type of secondary documentation could be used in a situation where primary documentation is not available. The next tool, I've got a link here to Appendix C, which I've been referring to, of the Foreign Affairs Manual, which lists the visa reciprocity. If this link at any point gets broken and doesn't work, you can simply Google Foreign Affairs Manual Appendix C, and within 2 clicks you should have access to it on the internet. That is updated with some frequency throughout the year, so if it showed 2 months ago that marriage certificates were readily accessible in Burma, it is worth checking back each time you get a new RFE to see if they've changed the status. Maybe now it says that they're not available. So what if Appendix C says that the documentation is available? And I just referred to Burma as an example, but if you have looked at Appendix C for Burma, you'll see that it infuriatingly implies that anybody in Burma can get access to anything, marriage certificate, death certificate, etc. And having spoken with dozens and dozens of Burmese petitioners, many of whom say, I've never seen a building that wasn't made out of bamboo, I've never been inside a government building, and I don't know what a birth certificate is, it would certainly seem that Appendix C's assessment is a little bit inaccurate for Burma. So if Appendix C says that documentation is available, you still have some additional cards up your sleeve that you can use to rebut the necessity of providing primary documentation. And in 8 CFR 207.7e, which we'll get to on an upcoming slide, it lists what type of evidence is necessary to prove a petitionable I-730 relationship. And what it states specifically is that generally you need the same type of proof that you would need in a I-130 situation. So that's why it refers you to Section 204 in order to tell you what type of documents you need to prove the existing relationship. But there's an important qualification in 207.7e that will help you out in a case where primary documentation is being demanded and Appendix C tells you it's available, but you know it's not. And what that is that it says that where possible, a I-730 petitioner will generate the same type of documentation as an I-130 petitioner. So it says in 207.7e, where possible. That qualifying statement opens the door for arguing the sufficiency of secondary documentation anytime that it's not possible to get primary documentation. So here's the regulation that I was referring to. You can see exactly underlined and in bold it says where possible this documentation for a I-730 petitioner will consist of the same documents specified in 8 CFR Section 204. Again, 204 is what lists required documents for I-130 petitions. But I think it's highly relevant that it states within the reg where possible. So you have the opportunity to argue that in your client's case it's simply not possible. That might sound a little bit loosey-goosey to you, but it works in many, many cases, and it's absolutely an argument worth making. So in other words, if your request for evidence is requiring of the petitioner documents such as birth certificate or marriage certificate, and the petitioner says those things are not available, and Appendix C does not help you, it tells you that those types of documents are available, you can still go to 207.7e, invoke that, and state, even though Appendix C says that those documents are readily available, they are not. In this case, it's not possible for the petitioner to get them. The beneficiaries may be in the country of persecution, in the country where the petitioner reasonably feared persecution, and as such, that in itself is a good argument to state why the beneficiaries may not be able to access primary documentation. So in other words, you can take a subjective approach by using 207.7e. Even if, generally speaking, documentation is available in Burma, it may not be available to unaccompanied Karen children whose parent was persecuted in that country, because they are living in the country of persecution. Even if documents are available, it may put them at risk to go and try to get those documents from the same government that persecuted the petitioner. Additionally, we haven't talked about late issued documentation yet in terms of how to rebut evidence issues that refer to late issued documentation. Well, that This is talking about when documents are issued long after the occurrence of the event that they intend to prove. So maybe someone was born in 1983 and their birth certificate is not issued until 2002. CIS will sometimes state that it is late issued and therefore insufficient, and they'll ask for documentation to be issued that was contemporaneous with the birth in 1983. So the service contends that this type of late issued documentation is less persuasive than documentation that's issued contemporaneously with the event. However, you can treat this type of RFE essentially the same as you would treat one that was requesting primary documentation that's unavailable. So in other words, if the RFE indicates that late issued civil documentation is insufficient, go ahead, refer to Appendix C of the FAM just to see if civil documentation is available for that country anyway, because if it's not, you can say, hey, not only is late issued documentation okay, but documentation that's civil issued cannot be requested of individuals from this country in the first place. So certainly the late issued documentation should suffice. If the FAM cites that the documentation is available, then you still have the 207.7e argument that we just talked about. So you can just refer to 207.7e and say that in your client's case, older documentation is not possible. Furthermore, you'll note it says where possible, documents will be such as those in Section 204. There's nothing in Section 204 that says that civil issued documentation has to be old in order to be persuasive of the petitionable relationship. And that's an argument worth making as well. So 204.2 that's listed there doesn't actually state that a birth certificate has to be issued contemporaneously with the event in question. Next, we're going to move on to a separate evidence issue. This is one that I mentioned I'm fond of dealing with. It comes up with great frequency, and I know we all have different populations that we work with. I've certainly seen this happen a lot in the populations coming from Ethiopia, so like Eritrean and Somali refugees, populations coming from Kenya as well, and even Central and West Africa. Those of you who are dealing with large Burmese populations, I've seen it happen there too. So in any event, this refers to a situation where your client files an I-730 for a spouse or child, and that spouse or child was not disclosed in previous immigration matters, such as the refugee interview overseas. In those cases, USCIS will likely issue an RFE. And an RFE of this type usually involves at least 2 evidentiary consequences. So first, USCIS will require that the petitioner provide a statement to explain why they failed to list their relative in the previous immigration matter. And secondly, USCIS will usually raise the petitioner's burden of proof from the preponderance of the evidence standard to the higher burden of clear and convincing evidence. They don't do this in every case, but they certainly do it in many cases. And previously when I mentioned that statutory deficiencies might be explicit or implicit, you may have seen this many times in an RFE and simply not noticed that it referred to a statutory requirement. So in other words, when the service says, since you failed to disclose your relative, you must prove the existence of the relationship by clear and convincing evidence, they're not explicitly stating you're being punished and your statutory burden of proof is being raised from the existing preponderance of the evidence standard to the higher standard of clear and convincing, and yet that's what's happening. So that's why I say you've got to start out by dissecting the RFE and looking at what the alleged statutory deficiencies are before you start crafting your rebuttal. So getting back to the issue of nondisclosure and how to combat it, there are many, many reasons why an individual might have failed to disclose the beneficiary in a prior application. And although ideally it would be best to deal with the nondisclosure affirmatively by addressing it with an affidavit that you file at the same time as the I-730, oftentimes you're not going to get that chance, and you'll be forced to deal with it in a request for evidence simply because you were unaware of the nondisclosure problem prior to filing. And so for this reason, it's a very good practice to ask every I-730 petitioner whether they listed their spouse and children during their overseas I-590 interview. Because that way, if you learn that your client omitted names during the interview, you may be able to head off an RFE by filing an affidavit with the I-730 that explains the reasons for nondisclosure. And again, reasons for nondisclosure really can vary, and they may include things like simple misinformation in the refugee camp, propaganda, information coming from relatives and friends, telling the individual that they should not disclose a spouse or child for a particular reason. It also might be because the petitioner's relatives, spouse and child are missing and presumed dead, so they don't disclose them at the interview. Or it might be something like the children are illegitimate children that the applicant was ashamed to disclose. Or it might even be something as simple as a perception that children or spouse that are not present in the refugee camp with the petitioner can't be listed, can't be included on the application. And there are other reasons too. So often the service will allege that a beneficiary who was previously not disclosed cannot benefit from an I-730. In some cases, they'll allege that a beneficiary was not disclosed when in fact they were. And the tough thing about this is that the I-590 application, it only has 4 spaces for listing children. So if you have a petitioner with more than 4 children, any additional children have to be added on an addendum to the I-590. And sometimes lost addendums account for this appearance of nondisclosure. So in other words, your client may have disclosed all their children, some of them may have been listed on an addendum, and it could get separated from the I-590, and then USCIS might claim that your client did not list all their children. So for this reason, it's really critical to review the I-590 where the client allegedly failed to disclose the beneficiary. But in many cases, USCIS does not give the attorney or accredited rep a copy of the deficient I-590. And so here we have a nifty tool finally getting to the bullets on the slide in order to include in your rebuttal. If your client is accused of not disclosing a relative in the RFE and the service has not provided you with a copy of the record that contains that omission, then you'll want to invoke 8 CFR 103.2, which is listed on the slide, in order to argue that the service has failed to comply with its own statutory obligation to give the applicant sufficient information to respond to the RFE. The applicant is permitted to inspect a record of the proceeding which constitutes the basis for the proposed denial of his case, and that's what 103.2, B84, and B16 describe. So again, the way that you would see this happen in practice is you get a request for evidence. It accuses your client of not disclosing. It says now you need to provide clear and convincing evidence of the relationship and provide a statement to explain the nondisclosure, and they don't actually give you the record that contains the alleged nondisclosure or the alleged omission. Then you can invoke 8 CFR 103.2 in 2 different ways. One is you can say that the petitioner has not been given adequate or sufficient information to respond to the RFE, because if you haven't been given a copy of the I-590, you really haven't been given sufficient information even to assess whether there was actual nondisclosure. The second, and I think stronger point in 103.2 is that you'll see there's this directory language in the regulation. It says after an RFE or notice of intent to deny has been issued, an applicant or petitioner shall be permitted to inspect the record of proceeding which constitutes the basis for the decision, except as provided in the following paragraphs, and then it gives a couple different exceptions to this requirement. But this actually states that USCIS has no choice. It shall provide the petitioner with the record of the proceeding which contains that adverse information, which constitutes the basis for the proposed denial. The exclusions that it lists, in case you're wondering whether or not in the case of this, I-590, it might fall under one of the exceptions that are referred to at the end of that paragraph. Among those are classified information, so the service does not have to provide the petitioner with classified information. Another one is adverse information unknown to the petitioner. Now, that might at first seem to be problematic, but it's really not. If you think about it, the I-590 application or any other benefits application that the client has signed in the past, if it has adverse information on it, it cannot really be classified as adverse information that's unknown to the petitioner, because if the petitioner actually signed the I-590, one would expect that he knew about the information contained in the I-590, that he swore under a penalty of perjury what was contained in it. And so it's just not adverse information that's unknown to the petitioner. It's adverse information that is known to the petitioner, if it exists at all. So both of these provisions in 103.2 can be used in your rebuttal response if the service demands that you explain a non-disclosure of a relative. You can say, you have given us insufficient information to respond, and you need to give us a copy of the I-590 in order for the petitioner to be able to respond to the RFE. Some of you may be grimacing just because all that really does is it defers the eventual fact that you're going to have to respond to the RFE totally, and it delays the necessity of responding. It demands that they give you the I-590 in order to respond. And that's true, but again, you really need to see that I-590 in order to know if there's even non-disclosure. And we'll go over some examples where you'll see that when the service says that an applicant has not disclosed the beneficiary, that in fact they did disclose the beneficiary.
Heather, we have a question from Chuck. He writes that in his experience, when non-disclosure is claimed, the NSC sends a copy of the I-590, so you do have a record of the proceeding. Is this true in general? It might not be the same for the TSC petitions. Do you have a comment for Chuck's question?
Yeah, I do. I think Chuck is right. If they provide you with the I-590, you don't get to use 103.2 anymore. You really only get to use it if they don't provide you with the I-590. And this is one of those procedural differences between Texas and Nebraska. Texas is ferocious when it comes to these I-590 RFEs. It doesn't include a copy. Our office frequently ends up having to make the 103.2 argument. Sometimes the petition still gets denied, and then we have to motion to reopen it before we can get an adjudicator to acknowledge that we really do need a copy of the I-590 in order to sufficiently respond to the RFE. But I think he makes a good point. This is only a useful argument in responding to the non-disclosure if you don't have a copy of the I-590. If you've already got the copy of the I-590, which it sounds like Nebraska is better at actually sending the representative a copy, then you've got to work with the contents of the I-590 combined with the petitioner's testimony in order to figure out how to argue that either the non-disclosure was reasonable under the circumstances, or at least understandable, or that there was no non-disclosure at all. And I'll go over some examples of that. But were there any other questions, Tara?
At this point, there's not. Thank you.
So moving to the next segment, which goes to Chuck's questions as well, you really need to investigate the reasons for non-disclosure thoroughly. USCIS almost always is going to request a statement to explain why the petitioner failed to list their relative in the previous matter. And so you're probably going to need to do an affidavit from your client in order to explain the non-disclosure, which is all the more reason to be really clear on the reasons for non-disclosure. There are many reasons that there might be apparent non-disclosure, and some of them are going to provide you with a really great rebuttal reason. So if you look at the first bullet, the I-590 signature date might actually predate the creation of the spouse-child relationship. So for example, if you have a petitioning father for a child and USCIS says you failed to disclose your child on the I-590, therefore this can't be approved. But you look and see that the signature date on the I-590 is at a time that that child actually would have been in utero. That child may not have been born yet. And as such, that's not non-disclosure on the I-590. That's just a factual impossibility. You can't disclose a child that is not yet born, that doesn't yet have a name and a birth date. So one thing you need to keep in mind is that the appearance of non-disclosure does not equal non-disclosure. A second example of that might be a petitioning individual for their beneficiary spouse, if they did their I-590 interview, signed the I-590, and then got married to their spouse within the next few days, weeks, or months before they arrived in the United States. So there's still a petitionable relationship there, because 207 and 208 of the INA that talk about petitionable derivative relationships for refugees and asylees say that as long as the relationship existed before the refugee's date of admission under Section 207, then they should be able to benefit. And so if you have someone who got married after the date of their I-590 signing, that again is also not non-disclosure. It was factually correct at the time of the I-590 interview. Furthermore, there are other reasons that are obviously very explainable that would be in favor of approving a petition that involves non-disclosure. Like if your client thought that their missing spouse or child was dead, that's certainly a reasonable thing to explain in an affidavit. Less desirable reasons for non-disclosure might be that your client willfully misrepresented for some reason. This certainly happens. In those cases, you're really going to have to pay attention to what the reasons are and screen to make sure that this doesn't create a different problem for your client. But sometimes there's just propaganda in the camp, and a client is told that they should not disclose a spouse or child who's, for example, not present in the camp at that moment. And they might fail to disclose deliberately, and that could be their reason for not disclosing. Now that's going to be a delicate thing to address in the affidavit, and yet in most cases you really should address it in the affidavit, and you do have a couple of good reasons that the I-730 should still be approved. You might be asking yourself if it's wise to do an affidavit where the client admits to having misrepresented to something on their I-590 application, and that is a good question. It's going to depend on the nature of the misrepresentation, but in the case of a petitioner who simply failed to disclose a spouse or child, a really important thing to consider is that it's not going to be fraud. A misrepresentation is not always fraud. In some cases it is, and in some cases it's not. And so the failure to disclose a spouse or child at the refugee interview is totally immaterial to the benefit that the refugee or intending refugee is seeking. So the individual who's applying for refugee status, whether or not they have children and whether or not they're married, it's irrelevant to the principal applicant's claim for refugee status. It's a fact, and it's a misrepresentation of a fact, but it's not a material fact. And so in most cases, an issue of non-disclosure doesn't actually mean that your client has committed fraud. And as such, you know, describing the client's reasons for non-disclosure may both allow for the I-730 beneficiary to be able to come to the U.S., and it's not going to put your client at risk because it's not actually exposing them to any additional liabilities, and it's just not fraud.
Heather, as we're talking about this, do you know if there's a way that we can request a copy of the I-590? Obviously the FOIA is available, but do you know of any other way to request a copy of the I-590 to verify if the relative was or was not disclosed?
You know, Tara, we've brought this up at the past 2 meetings that we've done in Nebraska for the refugee asylee, you know, the biannual conference, and both times, both the USCIS and State Department people said, oh yeah, every refugee should get a copy of their I-590, but they don't. And so the only ways I know you've already mentioned, which is doing a FOIA to USCIS and doing a FOIA to the State Department. And usually we end up getting the I-590 back from CIS, but it just often takes so long that it's unhelpful during the life cycle of the request for evidence. So one thing that you may consider, although I know it's labor intensive, is file a FOIA every time that you file an I-730. File it to USCIS and specifically ask for the I-590. It's probably a good practice point, even though it's kind of labor intensive.
And one other thing to point out is that when you're filing a FOIA, if you specifically request a document, the response will come back faster than if you're just requesting the entire A file in general. So when you're completing that FOIA request, make sure you specify the I-590 and don't just say the entire A file. That's been my experience. It's a little bit quicker if you specify.
That's a great point. Yeah, absolutely.
Thanks, Heather.
Thank you. So some examples of these different situations where non-disclosure may happen that come from actual cases, I'm going to list off just a few of them. And I should also bring up, among the attachments that were sent to you for this webinar, one of them is something called a practitioner's resource, Evidentiary Challenges to Refugee Asylee Relative Petitions, and it's basically a glossary of the types of evidence problems that you may encounter with I-730 RFEs. And in that glossary, it includes everything from secondary documentation to non-disclosure to adoption. And so there are examples of cases, there are sample rebuttals, and the relevant code and case law, when it exists, are included in that resource to help you craft rebuttals. And so a lot of these examples that I'm going to give come from that resource. And you should have it. It should have been sent to you with the other materials for the webinar, so you can refer to it. Case examples include one where the petitioner was not yet married to his beneficiary spouse on the date of that I-590 interview. As such, that doesn't constitute non-disclosure. One, and you may have seen this, non-disclosure was because a JVA staff member in Kenya advised the petitioner not to disclose his wife and son, saying that to do so could slow the processing of the family's case. And the family's case was awaiting a medical expedite due to the PA's father's poor health. So in other words, in that situation, there was an agent of the State Department, because JVA is subcontracted by the State Department, specifically advising the petitioner not to disclose his wife and newborn child, saying that if you do, your case may be larger, that might slow case processing for your parents, and your parents are waiting on a medical expedite for your dad. So in that case, I mean, that's a really sympathetic reason when you look at it, because it involves a medical situation, and it also involves what is tantamount to the State Department instructing the petitioner not to disclose the spouse and child. Because if the JVA works for the State Department adjudicates the I-590s, that's essentially like the person who has power over approving or denying the application, telling you how to fill it out and telling you not to disclose your spouse and child. Another case involved non-disclosure where the petitioner totally contested the non-disclosure. She swears that she listed all her children. She's an illiterate applicant, so she couldn't read the I-590 to check for accuracy, but she just swears up and down, yeah, I listed my kid. Again, you're going to write that in an affidavit and respond to the rebut the I-730 RFE by stating, we just disagree with your assessment here. The petitioner has sworn that she did list all the children. There's no reason for non-disclosure. You know, it's an argument that is reasonable under the circumstances. In some cases, you'll find that the allegation of non-disclosure is just totally incorrect. And if you look at the I-590, you'll see that there are indications that there may be amendments to the I-590. So I mentioned the missing children situation where an addendum might be separated from the I-590. Something else you should look for is look on the I-590 content. Sometimes you'll see little handwritten notes all over the I-590, like a number with a circle around it, number 1, number 2, and then at the very end of the I-590 there's a page on the signature page that states, you know, I swear to the contents of this application and any changes authorized by me numbered 1 through 4, for example. And if you look on the I-590, you'll see that there's a little number 1 with a circle around it next to the section where you would list children or spouse. That indicates that the applicant has made a change to the content of the application. And so we had a couple of cases like that where even though CIS is stating that a beneficiary was not disclosed, when you look at the handwritten notes on the form, it would indicate that there was some amendment somewhere that's been lost, that changes to the original answers have been made. So I realize that's a lot of information, and it's a big topic, but it's one that I think affects a lot of people. So we're going to move on next to a different subject, touch quickly on this, and that is the issue that we confronted in the first example of out-of-wedlock children being petitioned for by their parents. So in the context of I-730s, the only petitionable relationship that requires proof of a parent-child relationship is that of a father to his out-of-wedlock or illegitimate child. In any case where you receive an RFE that requests proof of a parent-child relationship, you need to scrutinize the basis of the request to ensure that it's actually statutorily appropriate. Because if the petitioner is a mother, then there's no requirement of showing a parent-child relationship. So similarly, if the petitioner is a father who has legitimated his out-of-wedlock child under the laws of the country where the child was born or where the father resided, then there's no basis for that request of proof of parent-child relationship. So this is why at the top of the slide it says, when you receive an RFE that deals with parent-child relationship, first always ask yourself who the petitioner is. Since parent-child relationship proof is only required in the case of a petitioning father for his out-of-wedlock child, you can often rebut one of these RFEs by simply pointing out that the RFE is misguided, that the statute does not require, for example, that a mother provide parent-child proof in order to have her out-of-wedlock child benefit from an I-730. Looking at that definition of child again, which we reviewed at the beginning, it states that proof of parent-child relationship prior to the child's 21st birthday is only necessary in the case of a petitioning father. Another thing you can remember if you get an RFE is that you can use parent-child relationship as a resource. So for example, if you have a petitioning father who has filed an I-730 on behalf of his in-wedlock child, so he's got a child, he was married to the child's mother, and that child was born in wedlock. And let's even say that mother is deceased now. So he's not petitioning for spouse, he's just petitioning for his in-wedlock child who has a deceased mother. Well, you might get an RFE that states that you have to submit proof of the father's marriage to the mother to prove that this is a legitimate child. And maybe you don't have any marriage certificate and you can't find any primary documentation and don't have a good argument there. In that case, you could say, you know, in the alternative, even if this is an out-of-wedlock child and he was never married to the mother, we have proof of parent-child relationship. So keep in mind that parent-child relationship proof could actually be an evidentiary resource. It's not just the subject of scrutiny in cases where that's the perceived deficiency by USCIS. Some case examples where parent-child proof is requested include one case of a Liberian mother that we had. She had no parent-child relationship with her daughter. Her daughter was the product of rape. She never cohabitated with the petitioner. And so truly the mother just had no proof of parent-child relationship, and yet under the statute she doesn't have to be able to prove a parent-child relationship. The next issue that I want to address is one that refers us back to that first step in looking at the RFE, understanding it, and outlining a rebuttal. And that is identify and enumerate the legal deficiencies cited in the RFE. The reason that's so important is that sometimes you're going to find that there's not, in fact, any legal deficiency, that CIS is alleging something that's not a legal deficiency at all. And so in those cases, certainly you don't want to respond to a legal deficiency that doesn't exist. You want to challenge it. There are many examples of this, and this is why you've got to go to the statute anytime that a deficiency is being cited to make sure that the statute even requires what USCIS is requesting. So examples of this include an RFE requesting proof of parent-child relationship from a petitioning mother, which we just talked about. Additionally, there was an interesting RFE that our office received once that stated that the I-730 could be denied because the beneficiary child was not able to explain the circumstances of how he came to be separated from his petitioning mother in Liberia 14 years ago. This was one of those RFEs that you read it and you're sort of like, oh, my client's case is crappy. I guess we're not going to win this one. And then when you really start to scrutinize it, you realize that the thing that USCIS is complaining about is totally irrelevant. As we just saw in the case of a petitioning mother, the evidence required of the petitioner is just evidence that she's a refugee and evidence that the child meets the definition of child, which for a petitioning mother of an out-of-wedlock child, all that they need is a biological relationship. So the insinuation in this RFE was that since the child can't really explain how it was that he came to be separated from his mother many years ago, you know, maybe they don't have a relationship, or maybe he has a credibility problem. It doesn't matter if he lies through his teeth about the circumstances of separation. As long as he's biologically her child and was under 21 on the date that she applied for refugee status, then he's entitled to reunification benefits. So in that case, we're just able to point out that the service was requesting something not required by the statute. Didn't really submit any proof of anything at all. We just, you know, submitted a counter argument. Another example of this is where a request for evidence demands either birth certificates or affidavits of birth, proof of birth for a beneficiary spouse. So this is a situation where you might get an RFE demanding primary documentation, and if they're asking for the birth certificate of a spouse, you have to ask yourself, why is that necessary? That example is answered again by 8 CFR 207.7e, which tells us what evidence is required for an I-730 to be approvable. And it states documentary evidence consists of those documents which establish, one, that the petitioner is a refugee, such as, you know, the petitioner's I-94 card, and secondly, evidence of the claimed relationship of the petitioner to the beneficiary. And so in this case, you have to ask yourself, which one of those two components does a beneficiary spouse's birth certificate satisfy? It has nothing to do with the petitioner's refugee status, but nor does it have anything to do with the relationship between a petitioning spouse and a beneficiary spouse. So in other words, what about a spouse's birth certificate proves whether or not that spouse is married to the petitioner? It doesn't. It's irrelevant. And so that's another RFE that you can rebut by simply saying, this isn't required by the statute. My client's, you know, the beneficiary spouse doesn't have a birth certificate, but he or she doesn't need one. So this just summarizes what we've just gone over. Don't just assume that information is justified just because it appears in an RFE. Consult the statute first, since the evidence that's being requested may not even be necessary under the statute. And ask yourself, is the requested evidence material to proving the petitionable relationship in the first place? So before we break for questions, I was just going to point out again, you have this attachment to the webinar materials that's a practitioner's resource for dealing with I-730 RFEs, and it has a glossary of the evidence issues that we've talked about along with others that we didn't get to. Also includes regulations and case law for evidence issues and some model rebuttals as well, including templates. So at this time, if there are any questions, we can answer them.
We have actually a point that's more for comment, and if you could address this situation. We have a participant who says that he has submitted original documents from Somalia where the FAM indicates that such documents are not available. And then when USCIS receives the documents, it then says it then sends a letter or some type of request stating that these documents are insufficient due to unreliability. Have you seen this, Heather, and do you have any comments about that?
Yeah, I saw one like that, and it was even more unorthodox than what was just described, where the adjudicator in Texas actually called our office and said, I was in Somalia serving, you know, in the Army at such and such a time when the event in question was, and I know that you can't get that documentation. How did you get it? I would say, you know, that you have that 207.7e argument, where possible, documentation will consist of what's in Section 204. And I would say the State Department states that in Appendix C that nothing is available in Somalia. As such, the fact that we have something, that's more reliable than having nothing. And in the case of documents that are coming out of Somalia, I mean, it's true you want to make sure it's not a totally phony document, make sure it's not a fraudulent document, but there are little regional centers that are akin to government. There are little regional areas that create civil records, and even things like hospitals occasionally. And I think what you could do is say, in a country that has no government infrastructure and that the State Department in the FAM says cannot produce civil issued documentation, it's inherently unreasonable of USCIS to disregard anything else that the country could produce if it's coming from a smaller non-governmental or quasi-governmental entity. So just try to make sure it's not something that was, copied and pasted into a Word document by a notario or by some guy in Mogadishu with an internet cafe. Make sure that it's actually coming from some type of authority. But I would argue, towards the weight of the documentation that, under the circumstances, it's a lot better than nothing. That sounds like a weak argument, but I think it has merit.
I think it's also worth noting out that as preparing these forms and preparing responses to RFEs, we have to use our due diligence and make sure that we do what we can to ensure that, at least to the best of our comfort level, that these documents aren't fraudulent. So there is an ethical responsibility for attorneys and accredited reps to do the best that they can to ensure that these documents aren't fraudulent and that they do seem to make sense, even if the FAM says that they don't exist.
I agree.
Heather, thank you for answering that question. We have a few more. Someone is curious if you were successful when you challenged the I-730 denial for the child that wasn't able to explain how he was separated from his mother.
Yes, and he got here in February this year. And I would say, I should knock on wood, I shouldn't even say this out loud, but the only situation in an RFE that I have not been able to overcome is one involving cultural adoption, which I think there are so many counter incentives there for USCIS in terms of approving a cultural adoption that it may be something that is unwinnable. But the one about non-disclosure, I'm sorry, about the circumstances of the separation, that one was approved because it's not required in 207.7e. All that's required is that the mother be related to that child biologically and that the mother be a refugee. Whether or not he knows how he came to be separated from his mom is really irrelevant.
What about in the case of a situation that Sarah brings up? She has the question of, so she's under the understanding that you don't need to submit proof of a parent-child relationship when the mother is petitioning for the child. She asks, how does this compare with the I-130 where a USC child is petitioning for his mother? Same relationship, different form.
Well, it's because 204 is telling you all the documents that are necessary in order to have that petition approved, whereas 207.7e is what tells us in an I-730 what's required. So 207.7e says that only two things are necessary: that the petitioner be a refugee, and that the petitioner be a petitioning mother or a petitioning father. Gives the other possibilities. And so it just doesn't require proof of a parent-child relationship. 207.7e refers petitioners to Section 204 for the type of documents that are needed to prove the petitionable relationship. But again, the only things that have to be proven are that the petitioner is a refugee, and that in the case that the attendee just described, that the petitioning mother is in fact the biological mother of a child who is under 21 on the date of the refugee application. I don't know if that...
Okay, thanks. And that's a great response. I think that gets to it. Sarah, if you have a follow-up, feel free to type it into the chat box. I think we have someone raising their hand. But let me get to this question from Amber. She recently had the beneficiary receive a request for review at his interview overseas. The request for review stated that the embassy was returning the I-730 to DHS with recommendation to revoke the petition. The interview was October 5th, and the NBC says that they returned the petition to USCIS. But Amber has not yet received the NOIR or the NOID from USCIS. Do you have any thoughts or input as to how long it typically takes for an NOIR or NOID to be issued?
Regrettably, I do, and Tara, you might weigh in on this as well. But unfortunately, it seems to take, in most cases, a really, really long time. We've had some that take like 9 to 12 months, and I have one that we've been waiting on for like 14 months, which is just inexcusable. I have checked with Nebraska Service Center and Texas Service Center people about this problem to understand why it takes so long for them to issue the notice of intent to revoke. And what they've stated is just that once the petition has been kicked back from State Department, that they don't have a standardized way of working it back into their queue. So it sounds like it goes and sits on someone's desk and keeps getting moved to the bottom because it doesn't have a system of prioritization which forces them to be accountable about getting it back in the queue in a timely manner. So what I've done in those situations when it's really lingering is to contact either the congressional liaison person in Texas for I-730s there, or your community relations person for NSC, and put them on notice about the situation, and if necessary, go to your congressional representative to try to get them to expedite just the transfer of the file back to USCIS from State Department. But it's really frustrating.
Thank you, Heather. I don't see any more questions typed. Oh, we have one more. Okay, Christine is asking about cultural adoptions. Christine had asked in a situation where there was a father, or I'm not going to say father, there was an adopted child, there was a child whose mother had died, and the mother's boyfriend adopted the child, and by adopted I mean in quotation marks because there wasn't a formal adoption. She had a question about cultural adoption and whether anyone has succeeded in getting a child over without a formal adoption. Christine, my response is that when you file the I-730, there has to be some type of relationship, some type of adoption. So I recommended that you email the Law Library of Congress to get a copy of the adoption law from that country to see if that country somehow accepts or recognizes cultural adoption. If it does, then there's an argument that can be made that you could try to file the I-730. But other than having that cultural adoption being recognized, I don't know of any way that that child can immigrate to the United States. Do you have a thought on that, Heather?
Yeah, I agree totally. I think you've got to go to the law of the country where the cultural adoption took place. And the only ones I know of where there's both statutory adoption and then cultural adoption is also recognized include China and then the island of Tonga. And I think both of these are in the evidence, the evidentiary resource that's attached. Let's see, page 11 talks about cultural adoption. And so, yeah, you've got to go to the country where the adoption took place, the cultural adoption, and see if they authorize both statutory and cultural adoptions. The other argument, which I would say, Christine, we have not succeeded with, but I will continue to try repeatedly, just on principle, is if you're dealing with a country that has lost its judicial infrastructure. And so in the cases that I've done, this has been Liberia, during wartime Liberia. So that country has a family code that's pretty similar to ours in the U.S. since it was modeled after our laws. And so they have a really specific statutory adoption process, and they don't say that cultural adoption is lawful. However, if you look at wartime Liberia, particularly nobody had access to a functioning judiciary. There wasn't a way to effectuate a statutory adoption. And so I would argue there, even though you may fail over and over again, but one of us might win at some point, I would argue that statutory adoption was precluded by the wartime situation, that it was totally impossible if you have an absent judicial infrastructure, and that under the circumstances, cultural adoption was the only option, and that had statutory adoption been available, that the person would have done it. And you're still going to have to show the cohabitation and come up with some type of, what was the act or the circumstances that constitute the cultural adoption. Like, I think you're still going to need a ceremony, a contract, something. It may not have followed what the adoption statutes say that it should, but something symbolic of, I choose to adopt this child and here's how I'm doing it, even in the absence of the appropriate statutory mechanism.
Thank you, Heather. I don't see any more questions in the chat box. You can raise your hand. I will unmute you so you can ask your question, or feel free to type it into the chat box. We have another question here. Okay, I don't see any more questions, so I'm going to start discussing affidavits. Remember that at the end of my affidavit section, we will also open it up for Q&A. But feel free to type your question into the chat box, and we will try to get to it. So I'm going to be talking about affidavits. What is an affidavit? What are they used for? What makes an affidavit strong? What makes it weak? And some pointers that you should consider when drafting an affidavit and working with your client. So we're looking at the definition from Black's Law Dictionary as to what an affidavit is. So you're seeing that it's a voluntary declaration of facts written down and sworn to by the declarant before an official authorized to administer oaths. What this means in plain terms is that there's a person, the declarant, who wants to tell a story. And to make sure that the facts of those stories are truthful, he has to write them down and swear under penalty of perjury that those facts are true. And so to make sure that the facts are true, the declarant, the person telling the story, has to sign the story in front of an officer authorized to administer oaths, which in short is a notary public. So basically an affidavit is a mechanism that is a documentation tool that you can use to help your client tell a story or to answer a question that's sworn under penalty of perjury and is notarized. Essentially, one way to think of it is that this is a way for your client or your client's friend to give testimony. Now, testimony is usually given in a court of law, and you have to take an oath that you're telling the truth. And many of the cases that we work with when we're responding to requests for evidence for I-730, we're not given the opportunity to testify before an immigration officer or an immigration judge. So that's where you would use an affidavit. In many cases, the purpose of an affidavit can vary depending upon what you need to prove. So when Heather was discussing earlier, when there's the non-existence of a document, or your client has tried numerous ways to obtain the document but without success, you could use an affidavit to explain the non-existence of the document for the client. For example, after the because of the Haitian earthquake, a lot of the buildings that house these documents were destroyed, and let's say my client went to the Haitian National Archives to get a birth certificate, but it didn't exist. Maybe the Foreign Affairs Manual wasn't updated at that time, and maybe it said that those birth certificates still existed. I can use my client's affidavit to say what attempts he made to obtain that birth certificate and what reasons he received as to why it doesn't exist anymore. Perhaps the clerk said, you know, our building was destroyed and that birth certificate was in that building. So you can use the affidavit to explain the non-existence of a document. In cases where you're filing an asylum application or a self-petition for a domestic violence victim who qualifies to be a self-petitioner under the Violence Against Women's Act, you will need to provide the applicant's story. Sometimes the forms itself don't necessarily give you enough space to provide more information or more detail. So you can provide an affidavit to sufficiently detail the asylum claim. Also, if you have a third party, your client's friend, your client's family member who wants to attest that he or she was attending a wedding to prove the bona fides of marriage, this is a mechanism that allows the third party to offer a statement before an immigration that the immigration officer can read. It's also an affidavit can help to buttress facts, to corroborate the facts of the application or the facts of another affidavit. It also, the affidavit can help increase the credibility of the application as a whole or of the applicant's credibility. So one thing to think about is that if your client is saying that there's no birth certificate in Haiti because of the earthquake and the Haitian National Archives was destroyed, it might be possible to get an affidavit from the clerk who works in that building that was destroyed stating such fact. So that will bolster your client's statement as well. Also, as I mentioned earlier, it's to establish the non-existence of a document or methods that your client has used or that you have used to try to get a document but did not have success. And also sometimes you need to provide additional information to an immigration adjudicator. Remember, a lot of the forms that we work with, the I-730s, the I-485s for refugees and asylees, there isn't a way, in most cases your client or the applicant or the petitioner will not be given an opportunity to appear before the immigration officer adjudicating the application or petition. So if there's any kind of confusion or misunderstanding about that application or statements made within it, you might want to clarify that with an affidavit to kind of get it at to point that out and to say, this is why this looks, this might cause an understanding, here's why it might be a misunderstanding, but here's the reason why it shouldn't be a misunderstanding. So in some cases you might need to provide more information to the immigration adjudicator. Affidavits are only as good as their face value. Affidavits that are inconsistent aren't going to be afforded a lot of evidentiary weight. And also affidavits are at best secondary evidence. If there's an affidavit with a lot of inconsistencies, it's not going to be worth much. And also for some immigration benefits, an affidavit in and of itself is not sufficient to establish eligibility. We see this in DACA, which is for the DREAMers. It stands for Deferred Action for Childhood Arrivals. USCIS will not allow a DACA requester to prove certain facts in order to show that they're eligible for deferred action. They can use the affidavit to fill in the gaps. So for example, for deferred action for childhood arrivals, you need to show that you've been in the U.S. for a certain amount of time. If you have a gap in the documentation, let's say you have documentation that you were in the United States in 2010, in January 2010, June 2010, but then the next documents you have to show that you were in the United States in 2011 aren't until December, you could use an affidavit to show that you were in the United States from January until December of 2011. So it can be used to fill in the gaps. And I think the most important thing to know about an affidavit is that it can really only be taken at face value. You can't, the affidavit in and of itself might not be sufficient unless it's supported by other documents. So in affidavits that I draft, in order to increase the face value of the affidavit, I will often refer to other evidence that I'm submitting. So for example, if I'm testifying that, or not testifying, I'm drafting an affidavit for a friend of my client who went to his wedding, I might refer to photos of the friend at the wedding. I might refer to the wedding invitation envelope that was addressed to my client's friend. Anything that you can use to support the affidavit will really enhance its strength and evidentiary value. Let's take a look at these situations and figure out and just discuss what the limitations are to providing an affidavit in these types of situations. So in the first situation, well, what we want to determine, in which of these situations would it be best to advise a client that you would assist in drafting an affidavit to prove a fact. So there's a few things to consider here. We want to consider what fact needs to be proved, who is the person that's going to make the affidavit. So who is the affiant? The affiant is the person signing the affidavit, the person telling the story. And was that affiant able to provide sufficient detail to prove the fact that needs to be proved? So in the first situation, we have a client who receives an RFE for an I-730 requesting proof of the bona fides of a marriage, and the client wants to offer his own statement as proof. The limitation in this situation is that it's the client's own statement. He's not getting a statement from anyone else. It would be stronger if the client had a friend or a family member who has known him his whole life, who has known him throughout his relationship to his wife, to offer the affidavit, because the client's statement doesn't hold a lot of weight when the client is filing the petition and the client is trying to prove the fact. If you have someone outside of the petition, meaning not a beneficiary, not a petitioner, I think that affidavit would offer more weight than an affidavit from the client trying to prove the bona fides of the marriage. That's not saying that the client shouldn't submit an affidavit, but I would not want to just submit an affidavit from the client. I'd want to get a few more people to submit an affidavit so that together these affidavits are strong and they're all supported and consistent with each other. And then we have a second situation where a client receives an RFE for an I-730 requesting proof that his child was legitimated, and the client wants to offer a statement from his son attesting to their relationship. So again, we have one of the parties to the I-730 here would be providing the affidavit. Again, it's the same weakness as the first point. The son would be the beneficiary of the petition, and he has a stake in it. It would be better to get someone who's a non-party to the petition to write the affidavit. In the third situation, we have a client receives an RFE for an I-730 requesting proof of the bona fides of a marriage, and the client wants to offer an affidavit from the city clerk who performed the ceremony. Now, what's key to know here is that the city clerk performs numerous marriages each day. So the city clerk would be really best placed to say that he or she does 10 marriages a day, and he or she does it in a way that complies with the marriage law of that jurisdiction, and that because he or she has done it for so long, they consistently have a process they follow. So I think in terms of establishing that the marriage meets legal requirements, I think the city clerk would be best placed. But since the city clerk does 10 marriages a day and maybe 10,000 over his or her career, that city clerk wouldn't necessarily be best placed to testify or to offer a statement about the bona fides of the marriage. When we're talking about the bona fides of the marriage, I mean in the sense that at the marriage's inception that they met the requirements, that's fine, but it's not going to go so much to the intent of the couple in the sense that are they getting married for an immigration benefit, or are they getting married because they actually want to be married and start a life together. So the city clerk wouldn't really be best to talk about the relationship before or after they got married, or to really testify or to give detail about how the couple is as a couple to show that they had that they wanted to be married for a purpose other than immigration purposes. So then in our last situation, we have a client receives an RFE for an I-730 requesting proof that he was physically present at his wedding ceremony, and his best friend who is in the United States and is an LPR, and I'm going to add here who attended the ceremony, wants to provide an affidavit attesting that the client was at the wedding ceremony. This is really the best situation out of these four in terms of offering proof to establish the fact that's needed to be proven, and the affiant, it would be best placed to offer that statement. So we have the best friend. The best friend of your client. The best friend is not a party to the I-730. The best friend also attended the wedding. So since the best friend attended the wedding, he saw his friend at the wedding ceremony getting married. He saw the bride there getting married. He can attest to what happened at the wedding. And since he's your client's best friend, he can also provide other information that will corroborate or increase the credibility of the affidavit, such as your client talked to his best friend all the time about the woman he wanted to marry, and would be best placed to know the relationship from the start through the marriage. And also the best friend can provide little facts about the wedding ceremony, such as who attended, how many people attended. All this detail would allow for a strong affidavit, an affidavit that would be quite credible, because the more detail you provide, the better the affidavit is. And the detail has to be specifically tailored to what you're trying to prove. You don't want to add just detail for the sake of adding detail and having a long affidavit. You want to add tailored information. Let's talk about the pieces of the affidavit that make it really strong, or not that make it strong, but the key components of an affidavit. So when you're drafting an affidavit, you start with a caption or a heading which identifies who the applicant is, who the beneficiary or petitioner is, identifying information about that individual, such as their A number or immigration status, the type of application that was filed or petition that was filed, and the reason for drafting the affidavit is all contained within the captioned. The paragraphs will be numbered so that it's easy to identify in case this affidavit ends up in court, which paragraph you're talking about. Also, one of the main components is that the affiant has to state that they're signing under penalty of perjury. Because the affiant is not under oath, the magic words signing under penalty of perjury need to be in there somewhere within the affidavit. So the affidavit needs to be signed in front of a notary, which is another key component. And then we have the wherefore paragraph, which is usually the last paragraph. And the wherefore paragraph details why this individual, what the individual wants out of writing this affidavit. So usually it's, wherefore I request this I-730 to be approved because my friend John has a bona fide marriage to his wife Sue. It's establishing what the point of the affidavit is. And then, of course, the notary's signature. The caption or heading, I have a sample here of what my caption looks like. This is the caption that I use. Heather also provided a sample affidavit, and her sample affidavit looks, or sample caption looks a little bit different than mine. But these are the key components that you can see here. We identify which government agency this affidavit is going to. So in this case, with an I-730 RFE, it's going to USCIS within the Department of Homeland Security. This is where I would write the form number. So I would write I-730 asylee refugee petition here. Then you can write the applicant's name if it's an I-485. If it's an I-730, you can put the beneficiary's name and or the beneficiary's name, and then the petitioner's name with a number. And then over here, you just identify what this affidavit is for. So if we use the example earlier, affidavit to prove the bona fide relationship of marriage. Just something simple here so that when the USCIS officer is looking at this, they can identify what this affidavit is trying to prove. So this is what a typical caption looks like. Again, your caption might be a little bit different, and Heather's caption is different. It doesn't necessarily have to take the same format. There's no requirement for USCIS. In immigration court, it's a little bit different. Immigration court has a practice manual, and the documents you submit should comply with the practice manual. But as far as I know, USCIS does not have a requirement that the caption contain that look a certain way. So this is a good sample. You can stray from it, but try to keep the same information. And when I said stray from it, I meant stray from the format, but try to contain all this information. I'm going to go back to the PowerPoint. Okay, so we just went over what the caption or heading is. And the penalty of perjury and numbered paragraphs. What's the purpose of this? As I mentioned before, the affiant is not going to be sworn under oath in a court of law. So that's why the individual is signing under penalty of perjury, because it's giving the affidavit the strength of an oath without an oath being admitted in court. And it also gives the affidavit legitimacy. Without swearing under penalty of perjury, there's no reason to believe that this document contains the truth. The penalty of perjury shows that there is a consequence to lying, and by writing the affidavit under penalty of perjury, most people would assume that the affiant would not want to suffer the penalty of perjury. And then, as I mentioned before, the paragraphs are numbered consecutively, and that each paragraph should convey one topic or one idea, so that it's easy to follow, and that if it does end up in court, the judge or the counsel can point to the paragraph and identify it, so that it's easily available to identify. As I mentioned before, there's the wherefore paragraph, which makes the request to USCIS or EOIR, and then we have the notary signature, which is very important because it verifies the identity of the affiant. The notary asks for the affiant's ID, and then verifies the affiant's that the affiant is actually the one signing it. And it's also a way to kind of make the sworn oath of authenticity. And in New York State and North Carolina, attorneys are notaries, and I believe that's the way it is in most states across the United States, that if you're an attorney, you're also a notary. But if you're not an attorney, if you're an accredited rep, you can become a notary public if you take a test and pass it and meet the licensing requirements. The affidavit, the main piece of the affidavit is called the body of the affidavit. This is where the story is told, the affiant's identified, the relationship, if one is needed to be established between the affiant and your client is established, or the relationship between the affiant and the fact is established. This is the main place where you tell the story. This is where you want the who, what, where, when, why, and how, and explaining it. So what you would do in the affidavit is have a paragraph identifying the affiant. This usually contains the affiant's full name, the affiant's date of birth, address, and I also include immigration status, because if the person is a U.S. citizen or a lawful permanent resident, that kind of shows that they have a stake in the United States that they don't want to sacrifice. That means that their immigration status is important to them, and it just kind of gives the affidavit a little bit more weight. Also, with the affiant, if the affiant is trying to prove a relationship, you would want to show how the affiant is related to, and by related I mean friends with or family related to, or knows one of the parties to the relationship that he or she is trying to establish. So in the case of the examples given before, where there's the best friend trying to establish the bona fide relationship with the petitioner, the bona fide marriage of the petitioner, the best friend would want to say, I have known the petitioner for 10 years. We went to high school together, and we always hung out in high school. We're in the same math class. You want to give context to the affiant's relationship to the petitioner or beneficiary, or to the fact that's trying to be proved. You also want to explain why the affiant is able to provide details that he or she is providing. So in the context of the example from before with the bona fide marriage, that would be I attended the wedding ceremony, therefore I can attest that John Smith was at his wedding ceremony. You want to explain how the affiant has the knowledge to give details about the information contained within the affidavit. And you want to provide enough detail, enough information to show, to establish the fact or to establish the non-existence of a fact. So if we're talking about the marriage ceremony, you don't want to just say that my best friend Bob Smith, the petitioner, was at the marriage ceremony. You want to say a little bit more detail about it to prove also that the affiant was there and to prove that he was really paying attention at the marriage ceremony. So you might want to give information about where the ceremony took place, how many people were there, maybe comment on something that had happened or some type of cultural event that occurred during the marriage to show that, to give context, because the more context, the more detail, the more pertinent detail that's provided, the greater weight the affidavit will be given, and that will enhance the evidentiary weight that it's given. And remember, it increases its credibility because these affidavits are only as good as their face value. And as I mentioned before, I would also refer to other supporting documents, and I might include evidence to just support the contents of the affidavit. So for example, when I submit an affidavit, I submit a copy of the green card or U.S. passport or certificate of naturalization of the affiant to prove their identity. I might also prove that that he or she was at the wedding ceremony with photos, or that he or she is the godmother of a child that the affiant is providing detail on to establish the relationship. So you add additional evidence just to show, to bolster the affidavit and enhance its credibility. So that's something else I would suggest doing, to refer to evidence that you're submitting in response to the RFE to show that the whole package as a whole really supports what needs to be proven, or to provide additional documents just to prove the contents of the affidavit, just to make it stronger. Let's take a look at this affidavit, and I'm going to ask you to type this into the chat box. We have a body of an affidavit right here, and I'd like you to take a look at it and to think what's missing from it. So we have, I, Jim Smith, hereby swear under penalty of perjury the following. I'm writing this affidavit to prove my friend John Smith attended his wedding. I'm a native and citizen of Canada living in the U.S. at 123 Main Street, New York, New York. I'm an LPR. I met John in high school. We have been best friends for 15 years. John attended his wedding ceremony. He married our mutual friend Cindy Jones. See John's marriage certificate. Wherefore, I request that you approve John's I-730 filed on behalf of his wife, Cindy. So please type in the chat box what you think is missing, or the question box, what you think is missing from the body of this affidavit. Because since this thing is missing, it makes this affidavit a little bit weak. So Heather, do you see anyone typing anything into the question box?
Yes. Yeah, we've got a couple coming in. So the first one we have, missing from, this is from Christine, missing from body of affidavit, details about the wedding ceremony and a statement that Jim attended the wedding.
Exactly. That's the main thing that's missing. Is there anything else?
Let's see, you have a couple other reflecting similar observation. No details about the wedding, details about the wedding ceremony. He doesn't actually say that he attended it. It doesn't show proof that he witnessed the wedding. So, all right.
Perfect. Perfect. So even though we have the penalty of perjury statement, we have that he's been friends with John for 15 years, we have no basis to establish the fact here that Jim actually attended the wedding ceremony. How can he make this statement that John attended? So what if they've been best friends for 15 years? Maybe Jim was sick on the day of the wedding and didn't attend the wedding. How do we know? What do we need to enhance the strength of this affidavit? And Christine and others rightfully pointed out that you need to provide context as to how Jim can give this statement.
Right.
Was he there, or is he just making it up? Who knows? So this is an example of what you need to include within an affidavit to make it sufficient so that it's given the proper evidentiary weight that it's deserving.
There were also remarks that the appropriate heading is missing, information such as a number, date of birth and place of birth of affiant missing as well.
Yes, I actually kept those out because I wanted people to be able to read it on the PowerPoint slide, so I apologize if the caption's not there in the signature and the notary statement. Anything else?
Jim remarks that there's no statement that they lived together after the wedding, that there's any cohabitation.
Okay, that could be something that could enhance the strength of the affidavit, certainly.
And then
but what if they're in separate countries? Then that wouldn't be something that you would need to prove. But the cohabitation, if they did live together, would be something that would strengthen the affidavit. If not, if they're in separate countries, there could be some detail about how the husband sends money orders home, or writes his wife emails or letters every day. So there's a little bit more detail that could also be added. Anything else?
Yeah, we have a comment that was, if this was for an I-730, then the wedding hardly could have happened in the U.S.
Well, let's say it's an I-130. How's that?
Yes.
We'll just switch it.
Well, perhaps.
Well, even though it says I-730 here. Oh, and we don't have anything here stating that the wedding happened in the U.S. So I think we're covered on that front.
Jim could have been visiting, Mallorca or
exactly.
a glamorous place.
I'm going to keep moving forward. So if there are any questions or comments, feel free to type them into the question box, and I will be stopping at the end to take questions. And I'm going to move forward a little bit quickly because Heather and I have a great hypo that we want to get to, so that so you can consider how to respond to RFEs and using our hypo as an example. So when you're drafting an affidavit, one of the main things you want to think about is that what is the purpose of this affidavit? What is it trying to prove? If it's trying to prove the bona fides of a marriage, you don't want to include too much information about the relationship between the husband and his sister. That's really outside the context. You want to make sure that the affidavit is tailored to the fact that you're trying to prove, and that the additional information you're including within it supports the corroboration or credibility of the fact you're trying to prove it. And you also want to think about how detailed do the contents of the affidavit need to be. Sometimes less detail is more, depending upon the situation. Sometimes more detail is preferred. So you really want to think about the affidavit and tailoring it to what needs to be done. Another thing to think about is that if you're working with the affiant to write the affidavit, think about how many meetings you're going to need to have and prepare the affiant for that. If you're trying to prove that the affiant attended a wedding ceremony, you're probably only going to need one appointment. If you're trying to prove an asylum claim, you're going to need multiple appointments, very lengthy appointments. So you want to prepare the affiant for that. Let's see, and also think about what types of documents you can provide to bolster the affidavit, to bolster the details within the affidavit. And certainly always include some type of identity document from the affiant. And if you're drafting an affidavit that's quite lengthy, so in cases where there's an asylum claim or a VAWA self-petition, I will usually ask the affiant to write me their statement before they come in. Because normally there's a lot of information that needs to be conveyed. And remember, you as the drafter of the affidavit are not the story creator, you're the storyteller. So if you're trying to get the affiant or your client's story, you need a statement from them, not you making up the story. So in some cases it's probably best to ask the affiant to draft a statement for you before starting the affidavit. If it's something lengthy and a lot of detail needs to be proven, If it's something short or small that needs to be proven, you could probably draft that affidavit without having a statement from your client. And then would it make sense for you to have one affidavit or several affidavits from different affiants? In cases where there's a declaration, meaning a statement that's signed but not sworn to under penalty of perjury and that's not notarized, that declaration wouldn't be given a ton of weight, but if you can get affidavits from other individuals, if the affidavits corroborate the information in the declaration, then that will make the declaration stronger, and together as a whole would be afforded more evidentiary weight than just a declaration standing on its own. So, and make sure if you're submitting multiple affidavits, make sure they don't contradict each other, make sure the information is consistent throughout, especially with these USCIS applications and petitions, because remember, clarification is not going to be able to be provided in many of these situations where there's no interview, where there's no court case. And this specifically holds true for VAWA self-petitions. If you're ever doing a VAWA self-petition or application, make sure that it's consistent, because that's what the Vermont Service Center is going to be adjudicating the case on. I'm going to skip this for the sake of time. But basically, you can take a look at this after the webinar. It's asking what types of evidence would you submit along with this affidavit, or would you refer to in this affidavit that can enhance the credibility of this affidavit to show that it's true. So I'm going to hold off on this, but you can take a look at that after this webinar. The PowerPoint will be sent out, and so that's something that you can look at on your own. When you're drafting an affidavit, remember that you're the storyteller, not the creator. As the storyteller, you can use very, very colorful verbs, very colorful adjectives, but you cannot create the story. You cannot create the details of the story. Just remember to tell the story, and to tell the story in your client's voice. Your client is not well-versed with immigration law, does not understand the Immigration and Nationality Act nor the sections within it, so the affidavit should not contain legalese. It should not contain citations. This is not necessarily a document you want to use as a memorandum of law. It is your client's story, and it should be in your client's voice. So use language that's appropriate for your client given their education level, their English level, and use clear but descriptive language. Again, the immigration officer is not going to meet the applicant, the petitioner, or the affiant, so you kind of want to give that affiant a little bit of personality in their affidavit. And make sure before you start writing the affidavit, make sure that you understand the story and that you understand the story perfectly. Because if you're drafting something and you don't understand the story, or there's a gap in the story, or something sounds a little bit fishy, if you don't understand it, how are you going to draft an affidavit so that an immigration officer is going to understand it? The immigration officer is never going to meet the affiant. So make sure you wholly understand the story, and poke. If there's questions ask the questions. Ask 10,000 questions. And that's specifically true if you're doing an affidavit for an asylum claim. If you see a hole, that asylum officer is going to see a hole, and you're going to need to make sure that you can patch that hole. And in these cases, it's important to patch the hole before they get to USCIS. And don't add unnecessary information, but feel free to add emotion to the affidavit, especially if it's a very compelling story and sad story, and that will enhance the detail provided and might pull at the heartstrings of the officer adjudicating the case. Add emotions. It's okay, especially when it comes to sensitive topics of domestic violence and asylum, when there's fear of persecution. Those are very important places to add emotions. Emotions aren't necessarily as needed to establish a bona fide relation, the bona fides of a marriage, but if the affiant did cry at the wedding because it was such a beautiful wedding and she's known the couple her whole life, and that they really deserve to be together and they're a great fit and they love each other, that can enhance that. That can enhance that affidavit, but not in every situation would there be that much emotion at a wedding ceremony. But just something to think about. If you're going to add emotion, add it where it meets, where it's sufficient for the details that need to be proven, and if it makes sense to add emotion in that context. Do we have any questions?
Not presently.
Okay.
Hold on. We do. We got, as storyteller, should we take down the affidavit exactly as spoken with incorrect English language usage?
No. Because again, when you're storyteller, so you can make those tweaks to the story, because if it doesn't make sense on paper, it's not going to make sense to the immigration officer. So certainly, when you get a statement from your client, that statement is supposed to be the beginning of drafting an affidavit. It's not supposed to be the affidavit. So as storyteller, you can make those edits to the English, but I wouldn't use gigantic words in the affidavit that would be outside of words that your client would use. And again, if your client doesn't speak English, you can always have a translator. The affidavit doesn't need to be in the language that your client speaks. It needs to be in English. But if you are doing that, you want to make sure that you have an excellent translator, because the client or the affiant, let's say the affiant, is swearing to everything in that affidavit is true. You want to make sure that that affidavit is read in a language that the affiant understands, so that they understand that everything is correct in it and that you're getting the right story.
So
Any other questions?
Yeah, Tara, Rebecca has a question that follows your comments about using an interpreter. She says, if an interpreter is used to gather the information for the affidavit, should the interpreter's information also be included in the affidavit?
I don't think it's necessary. I mean, it would be good for you to have this in your file to say that there was an interpreter used, and get the interpreter's signature that they testified accurately, but I don't think it's necessary for USCIS purposes.
Okay, and then Chuck has a comment just following up from Rebecca's question. He says that he uses this language after editing the affiant statement. This statement has been prepared for me by personnel from the international rescue community. It has been explained to me in detail, and I fully understand its contents. Under penalty of perjury, I swear that the above facts are accurate. I guess to kind of put the reader on notice that it wasn't a totally organic statement in terms of organization, that there was preparation involved from the advocate.
And that's something you can totally include with an affidavit if that's something that your office has as a policy or procedure.
And that's all we've got presently.
Okay, great. Let's take a look at this sample body of an affidavit. So what we're looking for is what type of edits or additions would you make to this affidavit. I'm not going to lie, there are some mistakes in here. There are some things that are omitted, some things that need to be added. So I want you to read this over and type into the question box what you would add, change, or edit about this affidavit. And while you're doing that, I'm going to read this out loud because this webinar is going to be recorded. So I, Jane Smith, hereby attest to the following. I'm writing this affidavit to prove my friend Joe Clark legitimated his son Howard Clark in accordance with 8 U.S.C. Section 101, small c. I'm a native and citizen of Burma, born on January 5, 1973, living in the U.S. at 123 Main Street, New York, New York. I'm a lawful permanent resident. Joe made decisions in Henry's life, paid his school fees, and accompanied him to his medical appointments. Howard loves his dad, Joe. Wherefore, I request that you approve the I-730 filed on behalf of his son, Howard. Very truly yours, signed Jane Smith, sworn to before me this day, 17th December 2012, witness. Okay, so let's open it up to the question box. What is missing? What needs to be added or edited from this affidavit?
Okay, they're pouring in. All right, first we have remove legal statutes, expand,
avoid legalese.
Sorry, Tara, expand some on the support for child provided continuously, and maybe refer to additional evidence submitted, such as receipts for payments, etc.
Perfect. You see that that's missing.
Andrea says there's no real proof of fatherhood.
Mm-hmm. That's a great point. We don't have anything here showing that. What is Jane actually saying? She's just making a statement that Howard loves his dad.
Right. And
she's not providing any detail as to what she's really trying to establish with that statement.
Right. And Janice comments, and this kind of also refers to that same issue, or the absence of a personal knowledge, which is, how does Jane Smith even know Joe? When and where did Jane and know Joe each other, and what did she actually see? So she's commenting on, you've got to establish that the affiant has personal knowledge of the events in question.
Exactly, because right now this is a very weak affidavit. We don't even know who Jane Smith is other than she's an LPR and where she's from, but how is she related to Joe or Howard in that fact?
John comments that we're missing the penalty of perjury.
Yep. Hereby attest is not sworn under penalty of perjury.
And John also comments that it's missing explicit statements that the affiant has seen specific evidence or acts. So again, the personal knowledge, deficient in the personal knowledge area.
Excellent.
Also says LPR should include the A number or a copy of the I-551 attached to the affidavit as supporting documentation.
Exactly. So proof of who Jane Smith is.
Right.
What about who's Henry?
Yeah.
Joe made decisions in Henry's life. I don't know who Henry is. This points to the fact that consistency is super important. If you're talking about Howard, and then Henry makes an appearance, is Henry supposed to be Howard? Make sure you read your affidavits before you submit them, because, again, this is the only thing the USCIS officer will be looking at to determine the weight he or she gives, the evidentiary weight he or she gives. And if there's inconsistencies in it, that's not a very positive thing you want that officer to see. What about witness? Sworn to before me this 17th December 2012 witness. What's the validity of, what value does a witness add in this context? Not much. We want a notary public, not a witness's signature. Would you also, one thing to think about, would you want to use your client's would you want to use first names or would you want to use last names? What kind of tone are you setting in the affidavit? Okay. And what's the point of paragraph 4? Howard loves his dad, Joe. Who cares? What is that? How is that adding to proof of the legitimation? It's not adding a whole lot on its own. Are there any other factors that people have pointed out?
Not ones that haven't already been repeated in some version.
Okay.
More detail on the nature of the relationship, more personal knowledge.
Great. Okay, so the tips that I offer are very much similar to the tips that we've already discussed. Make sure you explain to the affiant at the first meeting the purpose of the affidavit and the type of information that you will need to solicit from the affidavit, including the questions that you may ask. Be patient with the affiant. Sometimes the story might appear inconsistent because they haven't thought about it in the way that you're thinking about it. They probably haven't thought about it from the angle of what you're trying to prove. So be patient with them. And seek out details and clarifications if need be. Remember, if it's the affiant's story, not your story, so listen to the affiant. Be open-minded, and if you're talking about information that's difficult for the client or affiant to make sure that you have appropriate referral services. So, for example, with domestic violence victims or victims who've been persecuted, you might want to refer them to a mental health counselor because you'll be drawing out information that's difficult to recall, and that might bring up all sorts of emotions. So you want to make sure that the affiant or your client can handle that. In some cases, you might be trying to convey a very complicated message to USCIS, so you want to make sure that your affidavit is organized in a way that makes sense, usually giving details chronologically or using headings to help organize it. With regards to asylum or VAWA, I usually add headings that spell out the requirements and then details provided as to how they meet those requirements. And then just make sure that you have the typical structure I use in responding to RFEs to establish relationships, bona fides of a marriage, or legitimation. I usually start out with the purpose of the affidavit, what the affiant's trying to prove, biographic information about the affiant's relationship to the applicant, respondent, petitioner, or beneficiary, or to the fact that's trying to be established, why the affiant can provide the details. So in case of the affidavit we just saw, that Jane knew the father for so long and was able to see his relationship to his son, or that they attended the wedding, something to establish why the affiant can offer the details provided. And you might also want to list out the requirements of the benefits sought, and then include that wherefore paragraph as the last paragraph. Remember, it's very important that the affiant understands and knows the contents of the affidavit, because when it boils down to it, it's the affiant's story. So you want to make sure that it's accurate and true, and you can't stress this enough with the affiant. The affiant absolutely needs to review the final version of the affidavit, and because they're signing under penalty of perjury. And make sure that if your client is illiterate or can't read the language, that you have an accurate translator. I've had cases where if I have a client who's illiterate, I will sit there and read the affidavit out line by line and make sure that he or she understands the affidavit. And when the affiant's gone and you shut the door and you're doing the review of your response to the request for evidence, make sure you review with a fine-tooth comb the contents of that affidavit, because we don't want a Henry or Howard mixed up in the affidavits you're submitting before a USCIS officer. And also make sure it makes sense. If you're submitting things that contradict each other, you might want to make an executive decision, such as not to include an affidavit that doesn't make sense or that you think would not be helpful to establish the fact you're trying to establish. So right now, I am going to switch over to a hypo. I know we're like a minute or two behind. But if you would bear with me, I would be very happy if you stayed for this hypo that Heather so lovingly engineered. I'll read out the hypo. It's basically with regards to a response to an RFE for a beneficiary spouse. So right here you can see on your screen, this is the hypo. A Somali petitioner for his beneficiary wife was filing, let's say, an I-730. The petitioner and spouse were married in Kenya in Dadaab refugee camp 2 months after the petitioner's I-590 interview. And this is a case that we see often. But the marriage took place 3 months before his arrival in the United States under Immigration and Nationality Act Section 207. Their marriage was customarily celebrated in a mosque presided over by a sheikh pursuant to Islamic custom. No marriage certificate was issued. You receive an RFE, and it states the following. Review of the service record indicates that you are filing this petition on behalf of a relative whom you did not identify as your relative in your previous immigration matters. Therefore, this petition must be supported by clear and convincing evidence to establish the claimed relationship between you and the beneficiary actually existed. Please submit a statement to explain why you did not list the beneficiary on your previously approved I-590 registration for classification as a refugee. I'm going to start giving a response to this from the point of view of an affidavit. The petitioner can include an affidavit, and that affidavit would provide detail about the marriage ceremony that was performed. So since it was a customarily celebrated marriage ceremony, he could provide details about the mosque that he was in, the ceremony itself, what had occurred, and how it's typical in Islamic custom to have that type of marriage. You may also want to get an affidavit from the sheikh. providing detail about what an Islamic custom marriage looks like and how he presided over this marriage and that it followed Islamic custom. So those are examples of 2 affidavits you could submit. You could also submit affidavits from friends and family that attended the wedding, attesting to similar information like that. Heather, how would you respond to this in the context of not an affidavit? What other evidence would you submit?
So because one of the requests is that there be a statement submitted to explain the non-disclosure or why the petitioner did not list the beneficiary on the I-590 application, we've got to respond to those allegations of non-disclosure by rebutting them and explaining in our rebuttal, so not in the client's affidavit, that the I-590 interview date actually predated the creation of the petitionable relationship. And as such, it's not non-disclosure at all, because if he wasn't married to her yet on the date that he signed his I-590, then it wasn't non-disclosure at that time. It was factually accurate. Now, the RFE in this first prong is also requesting that a statement be submitted to explain why you did not list the beneficiary on the previously approved I-590. That is going to demand a affidavit response from the petitioner. So we're responding both from the legal practitioner in the rebuttal, is addressing the fact of non-disclosure, and additionally in an affidavit submitted by the petitioner, he's going to explain this wasn't really non-disclosure at all. I remember going to my refugee interview and then getting married to my wife a couple months later. I couldn't have disclosed her because we weren't married yet. And that doesn't have to necessarily be a separate affidavit from the one that Tara was talking about. You would consolidate those reasons within one affidavit. And that's how you could address both.
Yes.
So, yeah.
Oh, I was just going to say thank you for including that, Heather. I think I was just very much focused on the marriage ceremony itself as opposed to the non-existence of the relationship as well.
Great, and I think you covered the second prong, which the second prong of the RFE that states submit evidence to demonstrate that your marriage is bona fide, and you had said that you would include an affidavit from the sheikh as well as potentially affidavit from any witnesses that might be there and or anyone else involved in the ceremony. Did you want to elaborate on that second part any more? Or?
Actually, I just want to flip back to point 1 of the RFE. I was jumping ahead to point 2 in my mind, I think. But yeah, you would need to prove in some way in a statement from the petitioner would be best that he did not fail to disclose the relative on the I-590 because they weren't married yet. And in that statement, the petitioner can list the date that he got married and the date that he filed the I-590 and even the date that he came to the U.S. because that's the most important date is the date that he came to the U.S. It doesn't matter that the relationship didn't exist when he was completing the I-590.
And we have a question from Dana who says, wouldn't the JVA request a refugee to notify JVA or State Department if his civil status changes after the initial interview? And my answer to that is probably yes, and yet it seems it's still relatively irrelevant to the question. It's not non-disclosure. If it wasn't disclosed at the time that the relationship didn't exist, it's still not non-disclosure. And whether the agency wants to make additional allegations, such as you were supposed to notify the agency of any changes in civil status, then I'd let them go ahead and launch into that debate. But I would say there's all kinds of logistical problems with telling a refugee that he has to go back to State Department and amend his I-590 after it's been executed, because that would just be logistically difficult for the refugee to do. We know that it's really hard when they get their appointment for their interview. It's not something that they have great control over. So I think you bring up a valid point, but I don't think it would impact the way that you would respond to the RFE.
I agree with you, Heather. Should we get to point 3, which asks to submit a copy of the marriage certificate of Mr. and Mrs. Smith issued by proper civil authorities in order for the marriage to be recognized for immigration purposes? It must be civilly registered in the country where it took place. Heather,
right.
What are your thoughts?
Yeah, so this is one that you guys may have seen a lot. You get a request for evidence asking for a marriage certificate and stating very brazenly that for a marriage to be recognized for immigration purposes, it must be civilly registered in the country where it took place. Again, if we go to our the strategy for outlining our response to the RFE and first go to the statute and invoke the statute that gives the definition here for the petitionable relationship, we go to INA 101, and the definition for spouse or husband or wife is very unhelpful. What it tells us is that a proxy marriage that has not been consummated doesn't count as a marriage and doesn't create a spouse relationship. But it doesn't give any guidelines on anything else to say what is or is not a marriage. That we actually find in case law. There's a case called Matter of H, which states that if the marriage was valid in the country where it took place, then it's valid for immigration purposes. That case is referred to in the I-730 rebuttal guide that is among your attachments. But the reason that's so critical is because you see here that in the fact pattern we have a customary marriage. It's not civil registered. It happened according to Islamic tradition in Kenya, and it was not civil registered. So we maybe cannot get a civil registered marriage certificate. However, immigration's assertion that a marriage has to be civil registered in order to be recognized for immigration purposes is not true. What we do have to find out is whether or not the marriage was lawful in the country where it took place. So what we have to find out is whether a customary marriage, according to Islamic tradition in a mosque in front of a sheikh, is lawful in Kenya. And didn't have to go to the Library of Congress for this, just because every once in a while Google is handy enough to turn up results including foreign law. But according to the Kenyan marriage ordinance, which is actually listed when you go to Appendix C of the Foreign Affairs Manual, which describes the availability of marriage certificates in Kenya, you'll then find this link to the Kenyan Family Code, which reads, "Nothing in this act contained shall affect the validity of any marriage contracted under or in accordance with any native law or custom, or in any manner applying to marriages so contracted." And so essentially that's saying that civil registration requirement doesn't apply to marriages that are performed pursuant to Islamic tradition. Again, the nexus there is that because this was requesting of us a marriage certificate that's civil registered, our first step was to go to the definition of spouse, husband, or wife in the INA. Second step was to go to Appendix C of the Foreign Affairs Manual to see if a marriage certificate would even be available in Kenya. And what the Foreign Affairs Manual said is that, yes, marriage certificates are available only for marriages performed under the marriage ordinance. Then when we got to the marriage ordinance for Kenya, it stated that marriages performed under the marriage ordinance are valid, but so also are customary marriages or marriages done in accordance with native law or custom. Therefore, the fact that there's no civil registration requirement for these customary marriages doesn't mean that it's not a valid marriage for immigration purposes. So that's how we would go about rebutting that third part about it in the RFE. And I don't see any more questions related to the RFE. If you have any questions or thoughts, comments on the RFE response, please feel free to type them in.
We have a hand raised from Nodira. Nodira, I'm going to unmute you now. You're unmuted. You can speak to us and ask your question. Nodira, are you still here? Okay, I'm not seeing Nodira is with us any longer. So I'm going to turn it over to you, Heather. Do you see any other questions?
No, I exhausted my list of things to say about it. So.
Okay, great. And I don't see any more hands raised. So, okay, thank you so much for joining our webinar. This is a pertinent topic. One more question just popped in. Oh, Nodira is here. Nodira, I'm going to give you one more chance to ask your question. I am unmuting you now. Nodira, you're unmuted. So we should be able to hear you if you talk.
Or no, you can also just type into the comment box if you're having trouble with your mic or anything.
Okay, Nodira, you can email us if you have a question. You can send it to Aziza. And yes, we can't hear you. Okay, thanks, Nodira. We're going to end this webinar. Thank you all for joining. It was a pleasure presenting this webinar, and I hope you enjoyed it. And thank you, Heather.
Thank you so much, Tara. Thanks a lot. And yeah, thanks everyone. Have a wonderful holiday.
Yes, thank you. Bye.
The organizer has ended the session, and this call will be disconnected. Goodbye.